Present.
Trustee Liger? Absent.
President Dorsey present.
Trustee Liger is absent. Trustee McDonald, absent. Ex officio member Richardson, absent. Trustee Russell?
Present.
Trustee Smith? Absent. Chairman Barry?
Present.
4 present, 4 absent, which includes the ex officio member. Have a quorum.
Okay, so there are 2 items on today's agenda for the special meeting. One is a discussion on bill number 34071, which is, I guess, is the return to work bill, and the other is the discussion on BR 2106855, which is now bill number 340188. I'd like to switch those around and deal with the discussion on that bill first. The bill number 340188, which is the securitization bill that will finance the GERS system and take that around. I'm going to lose quorum in an hour at most. So as we stand right now, we just barely have quorum. So I'm going to try to assign about 35 minutes to the discussion on 340188. I'm assuming, without hearing no objection, that we're okay with the switch around of the topics.
I'm good with it. I'm good.
Okay. So
Do we have to vote on the switch around, Chair?
if there's no objection, you don't need to vote on it. Is anybody objecting to it? Okay. So the bill, what's before us today, which is now bill number 340188. And the discussion today for the board is whether the board is going to support the bill, its intent. I know our staff has some suggestions for ways we could strengthen technical adjustments to the language and stuff. But in terms of the core purpose of the bill, which is the refinancing of the GERS system, and then I guess the method of financing. I can't imagine we have any, as a board, we have any objection to the funding that's proposed. So the only other area of objection, I suspect, would be in the method of financing, which I guess, quite frankly, is not a board decision. I mean, to me, the GERS is a government entity. The government is the sponsor. The government determines the benefits, and the government determines how to fund those benefits. Our concern as a board is whether the funding is sufficient for us to deliver the benefits that are required. So bill number 0188, as I said earlier, is a bill that we've discussed for quite a bit. I mean, as a board, we had a lengthy discussion, at least 2 hours with the governor and his advisors. So we know what the bill is about. it's about providing significant additional contributions to the GRS, which as both the governor's financial advisors and the actuarial consultants have agreed would be sufficient to fund the system, to sustainably fund the system over at least the next 30 years, and in effect, take the GRS insolvency issue off the table for that period of time. Specifically, the plan, the financial plan that's embodied in the bill is estimated to provide annual contributions to the GRS ranging from $82 million a year to $158 million a year, according to a formula that's built into the law. Over the 30-year period, the total is about $4 billion. And as I said earlier, according to the actuarial analysis, it would fund the system sustainably for at least the next 30 years, and at which time the tier 2 employees will predominate in the retiree population. And we've been told for a while that the tier 2 members are actuarially sustainably funded. So as I said, as far as the money coming to the GRS, in terms of the amount of money and the impact, I'm not sure there's any basis for any objection to that. So the only pushback I've heard so far has to do with how that money gets to us. And so what we need to do at the end of this discussion is to make a decision. As you know, both myself, or both Mr. Nibbs and myself have been invited to the Committee of the Whole meeting on Monday. The Committee of the Whole meets on Monday to consider this bill. I think the expectation is that it will go into, once it's done with the Committee of the Whole, it will go right into full session and act on the bill. We have been, Mr. Nibbs and myself have been invited to testify. And so what the question for us today is to decide whether the board is in support of the plan or not. So I'd like to open up for discussion now, so that we make that decision today. And so we know to proceed, testimony, which, by the way, is supposed to be submitted today. So open for discussion.
So, Chair, morning to everybody. Trustee Dorsey. I had a few questions that I mentioned during the meeting with the governor. I didn't get any feedback from them unless it came and it didn't reach us. But my position is, as long as we're not signing off or subordinating any assets of the system, I didn't have a problem supporting this bill. Also, I asked for a plan B. I think it was David Paul. I asked if there was a plan B. I didn't get a response to that as well. But in my mind, the plan B, certain things would have to keep in place in case we have a virus that hits our cover over funding source. And that would be that I think it's 23% that still comes every month to the system. So that money needs to come in. that needs to continue to come in, as well as the employee portion needs to continue to come in. And then there was the other question was when they talk about the certificate to the system, as long as that means we're not obligating the system, I guess maybe that's terminology for how the money should be deposited based on the bill to the system. But as long as we're not obligating anything, I think we're fine from that standpoint. Outside of that, I figure we'll just have to continue to work on what we can propose as a board in addition to this particular bill. And I guess, Chair, I would just ask you for clarification from what we heard from yesterday. So this bill was the governor's bill, and this bill had the crossouts from, I guess, the Senate. So this will be the final document at this time. So as long as those areas are covered, then I definitely would support this at this time. So that's all I have to say at this time.
Okay. Anybody else?
Okay. Yes, I fundamentally, Mr. Chair, and with all due respect, I don't support borrowing at this point, and I've said where I really stand, and I could understand the climate of the territory, and I don't see this administration as taking constructive criticism very good. And I'm not going to be an obstructionist, but fundamentally, the whole borrowing is flawed. And when you really think about it, there is nothing preventing the Senate and the governor from simply getting the cover over every year, paying the debt owed to the rum companies, paying any bondholder, and just simply dedicating the balance to GRS. You don't need a special purpose vehicle. If you want to dedicate the rum cover over to the GRS, just do it. This borrowing is making money for somebody, and somebody getting fees, and somebody is collecting off of the people unnecessarily. And you dedicate the money from the cover over without a special purpose vehicle, and let the GERS use that as the insertion of capital. The same thing that the special purpose vehicle been doing. And several options. You could try the gasoline excise tax. You could ask Congress to increase the contribution of the rum cover over. You could get several other options that don't involve putting the territory in debt. And it appears to me that this administration don't want to listen to other ideas. And I respect that, but I ain't voting for this. The board will accept it without my vote. I'm gonna abstain because fundamentally, I was thinking about it last night. I can't support it. And I'm a resident of this territory, and the longer we do these kind of things, borrowing, dealing with, you know, corruption in a lot of things, WAPA and everything, and we just go along with it, I'm not in that no more. the borrowing scheme to create a special purpose vehicle and this and listen, it's a ruse to make somebody money. And I'm not in that, because the rum cover over, when I was representing Gruff, they started a petition to just get the rum cover over. We back to square one with the rum cover over, but it's all these documents in between. So I would like to hear our staff, their comments. I read it, and they made some good comments. Our councils made some good, and I would like to hear what they say to improve the bill. That it appears that the legislature doing their own bill, and it appears to me that they have GERS into it, and it's a significant improvement. So, Mr. Chair, I would like the staff, whoever the legal counsel was made those corrections, to explain those corrections to us now.
Okay, briefly, who would be able to do that?
Attorney Smith, could you put up the draft of the testimony on the two items that we would like to discuss tomorrow? There are some other items that we can also discuss, but we would not include those into the testimony. So we can do the testimony first, and then we can put up the other items that we are concerned about later on.
Yeah.
Okay, so let me find the testimony without the red line. So let me look for it.
No, you can do it just as you sent me this morning.
With the red line? Okay.
Yeah, sure, no problem.
Yeah, I need to see the red line because I comment on some of those red lines, okay?
No, the red line is, the original was given to Mr. Nibbs. He put it into the body of his testimony and then sent it to me to give some additional comments. So, but let me try to pull it up. I don't see how I'm able to share. Okay, here it is.
The majority of the red line in the last draft are those that we're not going to include, but would like to at least let the board know how we were thinking.
Yeah, it's not allowing me to pull up this document. I'm trying to
See.
figure out.
Well,
Okay.
you could begin with the inclusion of the actual system in the legislation.
Okay, wait 1 minute. I think I have it now. No, it's not allowing me to pull up.
Share screen.
Yeah,
Do you want to forward it to me, Attorney Smith?
okay. Yeah, for some reason it's not allowing me to do this. So let me just forward it to you.
Mr. Nibbs is all crucial, at least 4 or 5 crucial comments that I think the senators should be. I'm not sure what we're dealing with now, but
Are those comments going to be included in the Nibbs testimony to the legislature?
Well, we redlined and took out. We was looking at only putting 2 in there. One in regards to sending the lawsuit.
Yeah, the things you're looking for, are those items that are intended to be in your testimony?
What we're doing is we putting up the draft, and I asked Kathy to take out certain things. So only 2 items that we're concerned about to be in the testimony would be the rescinding of the lawsuit and also subordinating of the bond.
Okay.
There are other items that we would like to discuss with the board, and if the board agree, we could add those into the testimony.
Right.
yeah, please.
But what we did, Mr. Bowery, is the first part addresses the legislation. The other part where we had questions are more on the function of it. And those questions we believe go to the would go to the administration. And so those are questions that should be addressed to the administration. We don't think the legislature would be able to answer those questions. And it's not something that needs to go in the bill. It's just questions that we feel the system needs to know how it's going to operate with the bond. So Ms. Clendenin, if you could pull up the second document in that.
I didn't
That I
receive it I didn't receive it yet, Attorney Smith.
Yeah, well, Attorney Smith, precisely what you saying was my concern too.
Well, I mean, if these are issues that have to do with administering the program after, and as you said, they have nothing to do with the, they don't go to the actual legislation. This meeting today is about the legislation. What is before the committee of a whole, and which I guess I suspect will eventually go before the full body, because I mean, apparently both the governor and all the senators are already on board with this thing, the way it was developed. So, so if what you're discussing has to do with,
Okay, I have it up now. I'm not sure how I move this down, up and down. Okay, I can do it now. Okay, I have it up.
the decision I need from the board is to whether they're gonna, today is about
Legislation.
about
Right.
the
Right. The legislature is addressing this bill on Monday. That's why it's crucial that if we want these suggested changes to protect the GRS, we need to get it to them ASAP. Okay, so the first, if I may, Mr.
Go
Chairman,
ahead, you go ahead.
the first section was in the definitions, subsection KK on page 9, and it required that as a condition to the issuance of the GRS funding note, that the GRS have delivered or filed, a cause to be delivered or filed, a settlement agreement, which will release any pending claims, including all employer contributions, and dismiss any and all pending legislation against the government, and it would be deemed satisfied. So the GRS is willing to dismiss the district court case because the money being funded will take care of what the district court through the Third Circuit said was owed. But what the GRS would do for the Superior Court action is agree to enter into a consent judgment. Thereby, the court would still retain jurisdiction so that during the 30-year period of the funding agreement, should any of the parties violate the agreement, then there would be an enforcement mechanism. And so that's what GRS wants. We don't want to dismiss the case. We would agree to the consent judgment for the Superior Court case.
Why would you dismiss the district court case and just not state until the bond is issued, until the mechanism in place, and then dismiss it? Why
Well,
would
once they give us the bond, that was the thing. When they give us the bond, then we would dismiss the district court case.
Oh, because in other words, yeah, okay, because I don't think you should dismiss anything against the government because they have not acted in good faith toward the GRS system.
But based on the Third Circuit's argument and back to the district court, once we get the money, it will have satisfied their obligation under that lawsuit. So we really should dismiss that.
Right, once you get the money from the bond, yeah, okay. And
once we get the bond, right?
Yeah.
But as far as the Superior Court case, because this agreement for funding is over 30 years, we want to keep the court involved. So should any party default during the 30-year period, the Superior Court has jurisdiction and we can go back to the court for any violations of the agreements. Either party can go back to the court.
Yeah, okay, good. Okay, okay. You clarify that one. And this is important. That's why I'm glad that you explained it, because I saw this in your comments and this is important. Okay.
So Attorney Smith.
Yes.
Yeah, so if the government was to default, does that allow us through the lower court to go back to the higher court?
No, because that court case would be dismissed because the Third Circuit has already ruled on what they owe us and we will have gotten that. And so we
Oh.
can't go back to that because that court case was because of a consent judgment that was very specific. So now the case that we have in the Superior Court is for the ADEC. And this was covering the ADEC, the billions of dollars that are owed. So what we would be able to do is immediately file an action in the Superior Court under this case number saying that the agreement was violated.
Okay,
And then
so,
the judge would have a hearing.
okay, so when you say we received the money that would have been outstanding, we would have received it over how many years?
Okay, when you say the money that was outstanding, I'm not sure which money you're talking about.
I'm talking about the higher court. You said that we would have
Okay,
to
yes,
cancel out the case. So you said
that is a,
because it's very
sorry.
specific of the amount that we received. Are you saying that we would have received the amount in the higher court over what period of time?
It's going to be included in the 2022 funding of the bond. When we get the money from the 2022, that will have covered what the court owed us. What the court
So
said was owed to us.
So wouldn't we still leave that in place until we get the total amount, what was due in that court?
But
Yeah,
we
that's
will
what-
get, go ahead.
Yeah, that's what I'm saying. And that's what we agreed. Attorney Smith was agreeing that that's what is going to happen. We will satisfy that court order, and then we could leave the Superior Court, state or hold it in abeyance until,
No, I understand that, Trustee Russell. What I was asking,
date.
you blanked out on me a minute there, but what I was asking, Trustee Russell, you eliminate the higher court once you receive full payment, right?
Yeah.
It's not the
payment.
higher, it's not the higher court. It's just that the district court had jurisdiction at the time that the GRS took the court to the government to court. But what we're saying is, once we get the money for 2022, the debt that's owed under that will have been satisfied, and the court really no longer has jurisdiction. And so even
Okay,
if we need to get out of the case, and we should do it honorably, because once we've gotten
No, no.
money, we dismiss the case.
It's how you're explaining it, Attorney Smith. So when you say receive the money and come out, you're really saying in my terms, you're saying at the end of 2022, we will make that, do those documents send those documents to the court because we have received the full payment that was due in that case.
Well, the timing again, Mr. Dorsey, is something we have to work out because I'm not sure when we're going to get the money. And that's some of the questions that we have to work out with the central government.
The
So,
money
I
is going
can't-
the money is going to come, Attorney Smith,
Yeah.
consistent with the submit at the beginning of each fiscal year,
Mhm.
when the Treasury Department remits the matching fund to the special purpose vehicle,
That's
that at that point, that whole distribution of fund will take place.
Okay, so Chair, it's one lump sum payment to the system, right? Once a year?
Once a year, one lump sum payment.
Okay, what month is that payment?
I guess it'll be October. They will get the money at the
Okay.
beginning of the fiscal year.
So just for clarity, the amount that's due from this particular court is equivalent to the first payment of 2022?
Lot less.
Okay. Okay, well, that's fine. I think it just needs to be stated that way so that, someone picking up the document would understand that. Attorney Smith? Attorney Smith?
I don't know how much clearer I can make it, but I will look at it again.
Well, you can show it to me and then I can clear it up for you because 15,000 members understand.
Kathy, could we just tell them the amount that is the district court ruled on? And the Third Circuit did also, that they would have owed us $25 million, correct? And we already got 5. So they
Right.
owe us 19 million plus. That's all. And
Okay,
after that,
thank-
they satisfy, you can do, right? So it's $19 million that they owe us.
that's fine. And I like that to show up so that if when members come on the website, they can see as that money is coming into the system every year, that they can see how it's being applied as well. I'm not saying it's not happening now, but with this new bill coming in, we need to be able to show members that they can go up online and check to see how their system is doing. And if the government is holding up to their obligations along the way. So I think that's something we need to add in at some point as well. But thank you, Mr. Nibs.
Okay, if I can continue, the next section is section 1404, subsection 5B5. And that provision provides that if authorized in the future by the legislature, the corporation issues additional bonds and including but not limited to subordinated bond liens for purposes related to the corporation as contemplated by a resolution, and use the proceeds as contemplated in the related indenture, a supplemental indenture, and pay any related costs and ongoing financing costs. And it's our recommendation that this section be amended to ensure that any additional bonds that are issued would be subordinated to the GRS bond. So the GRS would get their payments first and not get payments after any debt service is paid to cover the other additional bonds. Because without getting that provision, when they pay debt service on the additional bonds out of the residual fund, it could reduce the amount that the GRS receives.
And precisely, that is very problematic because that's a setup to do other things if they want to do it that don't include the GRS. And I completely disagree with that provision, but go ahead.
Okay.
I have a question. I have a question about what you just read, Attorney Smith. I thought this special purpose vehicle was set up to fund the GERS. Am I missing something?
You're missing something, yeah?
Mr. Dorsey, I can only go by what's in the bill. So I can't answer what the government intended to do, why they put this in. I only address the languages in the bill that concerns or could affect the GRS receiving the money. I can't answer why.
I thought when we met with the team that first presented this, that after renegotiating with the two rum companies, taking care of their our obligations to the two rum companies, that the difference was coming to the system. Am I missing something?
That's the way it is written and it now, but this provision allows the government and the corporation to float additional bonds. And I mentioned that at the meeting with the governor, and the governor's financial person did say yes, and it's up to us to make sure, and fix it. So he did.
Okay, so Attorney Smith, we need to fix that language.
Well,
that
that's
needs to be corrected, because my understanding was if you're going to float additional bonds, I guess that would be needed to make up any differences or any hiccups in the process of paying out to the system. That's how I looked at that section. So if that's not how it is, Attorney Smith, then that's something we need to put in. We need to make sure that any additional bonds are going to be floated on behalf of the plan sponsor, that money is coming to the system, no other place. Not even the general fund.
Mr. Dorsey, that's why we put that provision into our testimony to the legislature saying, that we want this changed. So we can't change it. We can only make recommendations to the legislature. And this is what this is doing.
Right.
Yeah, but you see, you start to water down this bill over time. If you allow other funding, other bonds to be floated, and then you start doing other things, and then you get into other technicalities. So I thought the intended purpose of this special purpose vehicle, after paying the current debt to the two companies, the two rum companies, is paying to the system. Am I missing something, Chair?
I'm not sure where this conversation is going. I mean, what we have what we have is a bill before us. And the way I read the bill as a structure, that there's a formula that decides how GRS gets paid. And it's written into the law that it's $158 million minus the debt service and the refunding bonds. So any extra bonds ain't refunding bonds. So I'm not sure where it's going, but
Oh, okay, I understand what you're saying. I understand what you're saying. So,
besides,
I understand what you're saying, Chair. That's clear now. That's very clear.
the clear intention of the bill, and it's written as part of the law, is that once the money comes in, the special purpose vehicle or corporation is supposed to distribute the money according to a specific formula. Some of it goes to and part of the formula is that the GRS gets the difference between $158 million and the debt service and the refunding bonds, which is the bond. They have to refund the bonds because the current bonds have a lien on the matching fund. And so the government can't do anything with the matching fund unless it pays off the existing bonds. That's the reason for the refunding. The bonds, there's a bonds in place right now, about $560 million, something like that. And they have a lien on the matching fund. And unless the only way you could get out of the lien, which is necessary for the legislature to do what it wants to do, they have to pay off those bonds. And so what the SPV is going to do is issue a new set of bonds to pay off those bonds and get out from under the lien. And then it could decide then how the rest of the money goes. And the formula says is $158 million minus the debt service and the refunding bonds. Additional bonds after that are not refunding bonds. So I'm not sure.
So Chair, you made it very clear. You actually made it clearer. I guess how I would present it, Chair, and Attorney Smith, we have to protect the special purpose vehicle from regurgitating what happened to the Public Finance Authority and overfloating this and overfloating that. We need to leave it as it is, that we protect this particular corporation from doing nothing unless they're going to float additional bonds that would be needed for the system itself. I think that's a way better approach. So I think the language we need to recommend is that any additional funding, any additional floating of bonds should be germane to the system itself. And it shouldn't be for any other purpose, or we're going to end up with a situation where this special purpose vehicle may end up with a credit issue going forward. Because right now, once we do this, my understanding is this will be a A1 credit new corporation situation with the debt service being refinanced on the old bonds. So I think going forward, we need to put language in there to protect the integrity of the special purpose vehicle, that we leave that opportunity open in case we get a hiccup, as I said early on, that the rum cover over monies have some kind of virus in their industry where we don't get the level of monies coming in to the system to keep it up at the 158 million a year over time.
I see that provision.
Mr. Darcy.
And let me just say it. And Attorney Smith.
Let me finish.
Go ahead.
I think we need to put this discussion in perspective. We are responding as GRS board members. The decisions about funding and what bonds are issued are way outside of our jurisdiction. We can't put any language that binding the legislature on how to issue bonds. I mean, even the Third Circuit Court told us that even though they may agree with us on some payments, they have no authority to tell the government to legislate or to appropriate the monies. They said that right there is a separation of I guess, whatever, branches of government. So I mean, the determination of bonds and issuance of bonds is clearly and totally a legislative function. There ain't nothing we could do to tell them that.
Yeah, but Mr. Barry, we could suggest improvements in the language to protect.
I understand, and we talk about suggestion.
And that suggestion, what Attorney Smith says, that's a loophole.
But I'm agreeing with that. I'm agreeing with that. But when we start talking about they can't issue additional bonds and that all monies after bonds have to come to jail, we cannot dictate that.
I understand, but Attorney Smith, if you could get that loophole closed, I would like that.
Okay, and that's why we're, Mr. Trustee Russell, that's why we're suggesting that we put this language in. So if the government does float additional bonds, it does not affect our funding. And that's what we're trying to do.
Okay, thank you. Or
Attorney Smith.
If they float other bonds dedicated to the GRS, but that's up to them. But I think you did a sufficient correction as a suggestion, and I agree. That's one of them that I thought was necessary. Go ahead.
Thank you.
For me.
Attorney Smith. What I just suggested is a suggestion. It's not dictating. It's just a suggestion, as well as Chairman Bory. I'm not dictating to anybody. I'm here to make suggestions that maybe one or two senators might say, you know what, I didn't see it that way, but I see it now. So if we put it in writing to them, at least they know that this is something that we're also trying to protect the integrity of the special purpose vehicle. There's a great possibility if we leave certain things open, we can end up right back where we are in a few years. And we might have to come back again and do another special purpose vehicle again. This is a way to protect that. But I'm just saying it's just a suggestion. I would like to see it just be suggested, brought forward to the Senate, and let them decide what they're going to do.
Yeah, you see, I see the administration is seeing it as a necessary loophole in case they need money for the general fund later to do what they want to do. And if we close the loophole,
I mean, I'm not lawyer, but you can't close a loophole on legislature appropriation of funding.
No, you close the language, what they could do with the funding, and what Attorney Smith is saying, her suggested language protects us a little better with the special purpose vehicle. We can't be fully protected because there's still the sponsors, and they have to have access to capital. But we could protect ourselves by doing these things, and I agree with that.
Okay, so
we can't tell them what to do, but and that to be part of the testimony going forward, that they deal with this section.
Okay, all right.
I'll move on to the next section. In section 1413, subsection 5A on page 28, it states that the government assigns as security for the payment of the GRS funding notes receipts received by the government pursuant to the residual certificate in an annual amount calculated as follows. And it says 158 million of matching fund receipts less debt service on the initial matching fund securitization bonds and any other payment obligations under the indenture allocable to the refunding, redemption, payment, and defeasance of the government's portion of the existing PFA bonds, subject to any agreements relating to the distribution of payment of residual receipts deposited in the residual fund, the GRS residual receipts. It says, to the extent that there is a shortfall in any fiscal year, such shortfall shall be carried forward and shall constitute GRS's residual receipts in the next fiscal year until such shortfall has been satisfied. In all cases, the payment of the GRS residual receipts shall only be made from residual receipts. Now, this is something new to say that it carries over if there's a shortfall that wasn't in the governor's bill. So that is a plus that the legislature added. And the only concern is we weren't sure is that the provision appears to cap the amount provided at $158 million minus the matching fund receipts at payment of any other obligations. But the chart that we were shown by the government's financial team showed that in 15 of the 30 years after the payment of the debt service and other obligations, GRS would receive $158 million. So that's why we were a little confused on that, because if we don't receive the full 158 million, then the chart would show that GRS would be paid $4 billion 22 million plus, then that's not the amount the GRS would receive. So that's why we just need some clarification on that.
I'm not sure. Let me explain. The formula says that the GRS receives $158 million minus debt service on the refunding bonds.
Right.
The reason why it turns to, and that's over 30 years, but the refunding bonds are 20-year bonds. So, but in 20 years, all the refunding bonds would have been paid off. And that's why you get the whole $158 million from year 21 onto year 10.
Okay, it's just that the only thing is we noticed that this was new language added and it changed the language from the governor's bill. So what we were provided in the analysis from the government's financial team was a little different. So that's all we were making note of.
Yeah, but also it has a cap, and the residual is good because if that's a good addition. But when scroll, yeah.
So all we're asking too is will additional funds be provided during the period to make up for any shortfalls? You know, because depending on which years and the shortfall occurs, what happens if the GRS doesn't have the assets to fund the retiree payroll? So that's just a question that we need to take a look at. It wasn't to say anything about the language. It was more something that we should be aware of.
So and one of the things that they didn't do, okay, 158 to them, Mr. Bory, can't be 158 10 years from now. And that's a problem. That's why it shouldn't have a cap. And you taking what we could get now and without a clear understanding of how the future might go, the language should be a lot more expansive in this provision in there. And 158 now is not going to be what 158 10 years. That's going to be what 120 something. And then we still have to pay out to the retirees who have to, we got to adjust. So I don't know. I thought they would include in this provision an adjustment to take to account future financial concerns of the territory. And that's just my comment.
Calculation for the actuaries take it up to 30 years.
Yeah, but
and it shows that over that period of time, that it keeps it keeps the system solvent. I mean, the benefits, I mean, you can make the same argument about the benefits. $265 million benefits in 30 years and what the same as $265 million now.
Right.
Right. So they are present value calculations.
I understand that. And that's why I was saying in this language where they have, you know, they should have language.
I can't
to
hear you,
say
Attorney Russell. I can't hear you. Can you repeat?
If the numbers and significant changes in economic constraint, I was just saying there should be language to account for the future value by expanding in 158. The residuals tried to do it, I think. I think that's what they did. And I'll leave it there, but it could be a lot more clearer. The language could be a lot more clearer. But anyhow, I'm not writing the legislation, so we can move on. Kathy, are you going to include that in your comments?
That, I think Mr. Nibbs is going to probably include something of that nature in his testimony.
Yeah,
But as
he
I
should
said, Mr. Bowery, if we're only bringing
I
it to
just-
the
I
attention.
just want, Kathy,
Go ahead,
we
Mr.
have to go over this. I want to get some type of direction from the board. I'm seeing Mr. Bari has experience in this area. He's been around with OMB before, but with bonds. I don't want to go to the legislature and I say something and they ask Mr. Bari a question and there's a conflict.
Right.
He has explained a lot, and I'm understanding it a lot better how he explained something a while ago. So I think we need to be very careful because I don't want to show any type of separation with the board and the staff at that meeting.
Right.
Okay.
I agree.
I agree.
And Mr.
Right,
Nick, you know,
so-
Mr. Bowery can probably explain this because again, we were looking at what the governor's team gave us and the language, and then the legislature changed the language. So all we're saying is that the chart that the governor gave us, the government's team gave us, isn't, may change upon this. And so we're just wondering how that affects it. You know, that's all we're saying. We haven't seen a chart showing how this language change affects the GRS from the prior chart we said. But now that Mr. Bowery explains it, you know, he may, because he has experience, he may say, oh no, it's not of any consequence. So we have to rely on him. We're only noting the difference. That's all we're doing.
Well, the difference, I think, was explained with a residual. It means that we could get more, or that if we have a deficit, we could, it is roll over, and it's roll over with the treasury and the bond. I mean, the access to the money that the special purpose vehicle is supposed to give us. That's how I see it. Mr. Bowery, you see it that way too? Mr. Bowery,
I'm losing you.
you
I'm
see
not-
that residual?
Can't hear you, Attorney Russell. We cannot hear you.
But Mr. Bowery, based on your explanation that the bonds, the repayment for the bond are going to dissipate in 20 years and we will get the full 158, then that does change, but that wasn't shown on the chart. So, you know, then this probably is a non-issue.
Yeah, I mean, it was shown on the thing that came from Mr. Paul. If you look at David Paul, if you look at the schedule, had it in, it was in the presentation that the actuary provided. The first 20 years you have different levels of funding. Some years is 80 something, some years 144. And then from year 21 on is a flat number, 150.
Right.
And
Well,
that,
we were just,
okay. And that is because, as I said,
Mhm.
the funding bonds are 20-year bonds.
Mhm.
And in 20 years, they would have been paid off.
Mhm.
And so 158, the formula says 158 minus the bonds. The bonds are paid off, you get the full 158.
Okay, so then based on this language change that the legislature did has no effect. And that's all, we were just bringing it to the attention. That's all we were doing.
So,
Yeah, Mr. Barry is correct. I've seen it. After
Okay,
21, it goes to 158.
so then
so,
it's a non-issue.
so I mean, I think in terms, I'm trying to get the discussion with the board, because the issue that came up yesterday is whether or not the board is going to support it. I know when we had the discussion with the governor, he said, I guess somebody asked him, the discussion came up about board support. And his response was, it would be nice. And I took that to mean that he's subtly telling you that it's not really necessary. I mean, what we're going to be faced with tomorrow is the result of the governor and the legislature through the subcommittee.
Mhm.
And I don't think any senator dare vote against that,
I agree.
because they all campaign and that they'll fix GRS. And we have an election coming up and nobody has a fix. This is the closest thing we have to a fix. So, I think in terms of, for the purpose of this meeting, I'm reading the board sentiment, and I don't know how we want to express it, whether we want to do it formally or some, that after the discussion we've had, that we are in support of in general support with some technical adjustments which we'd want them to include. But the fundamental core of the plan, the financing plan, and the method of financing it, we are in support of that, I'm assuming. And that's my reading of the discussion today. And I'd like that to be stated specifically. So Mr. Nibbs, when he's writing his testimony, he's in sync with the board direction.
Right, and there was only one last issue.
Hold on,
That-
hold on, Attorney Smith. I have a question on that same issue. I just need clarification on if there's a shortfall in a particular year and it's supposed to be rolled over, but you have a shortfall in that year, where do we make up the difference?
Portfolio.
They keep rolling over.
Yeah, you would have to ask the legislature that, Mr.
I mean,
No, that's why I was saying
But
before,
based on
right?
this, it continues to roll over. Every year there's a shortfall, it will continue to roll over. So if in one year there's a $10 million shortfall, and the next year there's another $10 million, you'll have a $20 million shortfall. It'll just keep rolling over.
Well, that's why I was saying early on, if you guys were paying attention, if the government has the ability through the special purpose vehicle to float additional bonds, that would be the logical place to float them at that time to make up the difference. If it has the ability and the capacity to float additional bonds. And that's why I keep saying we need to tie everything back to what I call the golden goose, which is the system itself. So to me, that's another loophole that needs to tie back in. It's easy to sit here and say, we're just going to roll over 10 million or whatever the shortfall is and keep rolling over 10 million. I'm saying that's how we got in this predicament in a sense, but we have an opportunity now with a new special purpose vehicle that has the capacity to float more bonds. I think we should at least make the request.
Mr. Bowery, I would have to defer to your expertise. If the government is not able to pay the amount that's owed to GRS and they have to roll it over, will they have the ability to float more bonds if they can't make the payments that are already under the bonds?
the government always has the ability to float more bonds, subject to
Capacity.
two things, subject to the bond capacity.
Mhm.
And I guess there are two kinds of bond capacity. There's a legal capacity and there's a financial capacity. So, I mean, that the government always has the ability to float more bonds.
I guess I phrased that wrong. Would there be an appetite for somebody purchasing the bond?
I don't know, how are we going to answer that question 20 years down?
Yeah, so I don't know. I guess my point is this may be a non-issue because they may not be in a position to even float more bonds.
If they're
No,
not-
that's not correct, Attorney Smith. The reason why we putting this vehicle together, right? Why it's being proposed is because the PFA is not in that capacity. They're not in that position to have the capacity to do this because of their credit ratings, right? This new vehicle is able to do that. So you're saying after initially floating these bonds and refinancing the debt, so you're saying whenever this shortfall comes in the next 20 years, for example, the system wouldn't have the capacity to float
GERS.
additional bonds that cover just a $10 million or a $20 million? That's what you're saying?
No, I didn't put a figure on it, Mr. Dorsey.
The SPV has no authority to do anything other than what's in the legislation. It has authority to float one set of bonds. That's the refunding bonds. And it has authority to do the GRS. It has no authority to do anything else.
Okay, so you're saying, Chair, that after the special purpose vehicle floats the bonds, refinance the existing bonds of the PFA and floats those bonds, pays the two rum companies, they don't have the ability to do any other bonding activity through that vehicle?
No.
Is that what you're saying?
That's where we read the language.
Okay.
I mean, the SPV has very specific purposes. They are spelled out in the law. They can't
Okay.
do any more and they can't do any less.
So I guess I would ask Mr. Nibbs at this point, Mr. Nibbs, if we have a shortfall, as what was just said, then that means the monies that are coming in from the government currently and the monies that are coming in, the employees' portion that's coming in currently, is it to be that money will continue to come in during this period, that these special purpose vehicles in place?
Yes,
Or
those are statutory deductions. They must come in.
Okay, so then that money should be enough to cover supposedly those shortfalls is what we're looking at?
I don't think so. I mean, I don't know what a shortfall is going to be, but if there's any deficit, it will come from the portfolio.
Wow.
Trustees, we've averaged over the last 10 years about 115 million withdrawals from the portfolio. So any shortfall, I guess, like Mr. Nib stated, we would have to pull from the fund to make us whole.
We still need a plan B, the way I see this. I understand the legislation in front of us, but we still need a plan B. This is like putting all your eggs still in one basket in a sense. And I'm not comfortable with that part of it. And I mentioned that to the governor and his team, that we need a plan B. I asked them if they had a plan B. They didn't have a plan B, but we definitely need a plan B.
Okay, so but right now we have a plan A. The question we have is, what's the board's position about plan A?
Well, my position is right now, I want to let Kathy finish going through what she's going through before I answer that now.
There's only, I think, 2 more sections, Mr. Bowery, if you want me to continue. Okay, the other section says in subsection D, in that same section, the bill provides that upon the deposit of the government of the GRS funding note with the GRS shall be deemed the sole and exclusive owner of the GRS funding note, subject to the rights of transfer as set forth in the indenture and the financing document securing the note. And all we're saying is that we should be apprised of, it's not with this bill, but it's something that the board needs to know what its rights of transfer or what any limitations or whatever is going to be on in the financing documents. So that's just something we should be aware of. And then the last item I have, I believe is the last item, is in subsection G on page 29. The bill provides that any and all amounts budgeted by the government to be paid to the GRS during fiscal year 2022 shall, upon the issuance and delivery of the GRS funding note, be deemed voided, rescinded, and of no further force or effect. And we want to know, does this provision mean that the GRS will not receive the employer contributions in 2022 once they're given the bond? And also, does this relieve the GVI of its obligations under those provisions of the code? And we're saying this is concerning because the GRS relies, even if we get the bond in 2022, we still rely on the employer contributions to make payroll. And if we don't get those employer contributions, and Mr. Henderson could speak more about that, we will have to pull from the portfolio.
What in that suggests to you that we won't get I mean, this
Well,
whole.
the language, it says any and all amounts budgeted, which is the employer contributions, are budgeted to be paid into the GRS during fiscal year 2022 shall, upon the issuance and delivery of the funding note, be void and rescinded.
Yes, and I read the language that same way.
So we need to say, other than the statutory, other than the payroll contributions, right?
Mr. Bowie, I read that language the same way. That they'll give us a lump sum money and they don't have to pay anything into us. That's very problematic.
Okay, so we need to clarify that, Kathy, but to make sure that it says, obviously the whole plan assumes that those payments continue, otherwise it doesn't.
Right.
The whole analysis that has been done that says it's a sustainable plan assumes that those continue.
Exactly. And we don't understand why the legislature put that in there. I mean, why did they do that? So
I think why they're doing, and you could clarify it by let's say, make sure it's except for the regular, however you want to put it, payroll-based contribution. Because I mean, I think what that has to do is those other little appropriations that have been made before that's been outstanding. I think last time Mr. Nib says about $9 million worth appropriations that we haven't been paid for.
That's about, it's 10, I think it's 10 million right now.
So there's a couple of, there's a couple of appropriations that were made.
Like in 2019, 2020, and 2021.
Yeah, that they haven't fulfilled.
Correct.
okay, well, according to the language, Mr. Bowery, it says all amounts budgeted in 2022. So if those amounts are owed from prior fiscal years, they're not alleviated in this. It's only those budgeted in the fiscal year 2022 budget.
Okay.
And that's the reading of the language.
I think so. Your concern is whether that eliminates the
Employer contribution.
Okay, so we propose that be clear.
Exactly.
It's obvious that is not intended.
Exactly. So I agree.
Numbers don't work if it goes up.
Mhm. Right. So that was the last thing that we had on the legislation.
Okay, and may I comment? This provision here is, why are we restricted from getting any other appropriation or budgeted when this law moves forward? Why are there restrictions in this law on the GERS receiving money or budgeted money or anything like that? I don't agree with that. And your concern, Kathy, to me, it's problematic because it's trying to say that the fundamental purpose of the GRS of getting employee contributions can now be forego.
Right. And my concern is, Attorney Russell, you're right. We're only getting a bond. We're not getting cash. So that's something that I don't know if they even realize what the language meant.
What you're saying? We're not getting cash?
No, it says we're going to get upon the bond. Once they deliver the bond to us. And that's my concern. It doesn't say that upon one receipt of the monies from the bond, it just says once they give us the bond. So I'm going by the plain language.
Mr. Bori, the plain language of this legislation doesn't satisfy the intent what everybody's saying is supposed to do. They got too much loopholes in it, and when a language could be interpreted differently, it's a problem. And when a law is this big and this cumbersome, people will take provisions and interpret it what they want it to be. And that's a problem. This section is a real problem. I
So
don't
what
know how we could address it, but it's a real problem. And I
Well,
thought your comments, Attorney Smith, were well taken.
Okay, and I'm in agreement with it. And I'm saying the question is twofold. One is two things. Is that a problem big enough to object to the rest of the whole package?
No, we just request that the
No,
legislature.
I'm asking. We're talking about the
No,
four.
okay, let me tell you,
Oh.
Mr. Bori, let me say it clear, okay? And very, very clearly, I support the effort to fund the GRS because this is the only effort we have. The method doesn't show me a good faith method in really solving the GRS problem. The method to me is used for something else and creates a problem from my point of view, because the borrowing, the same vehicle was twice rejected by the legislature. And they have more information and they had testimony on that. This is a corrected.
That's
Yeah,
not true.
this is okay.
That's not true.
Well, the legislature rejected a special purpose vehicle.
Legislature passed it in both cases, both times.
Yeah.
I mean, the legislature passed it, and they actually were going to market, and it was stopped. So I'm not sure.
Okay.
It's not
Okay.
true. Both time legislature approved it.
Yeah, okay. And you're correct. The legislature, okay. I'm not trying to obstruct anything. I disagree with borrowing again. I think
All right, so
so that's fundamental. And I read everything that Kathy, and I thought she obviously wants to correct some loopholes, and I agree with that. I can just abstain because my conscience don't allow me to support this like how everybody's supporting it. Okay? Good.
all right, that's fine.
And Mr. Barry, like you said before, all we have to do is put in the language excluding the employer contributions, and that solves the problem.
Just to clarify.
Yeah.
I mean,
We can solve the problem. It's not
Yeah. I have no problem with that because I mean, clearly it was the intent.
right.
I have a point of clarification, Chair, to Attorney Smith. That same provision, if I read it a little different, right? I read that provision that it would exclude the government's portion, employee portion going into the system. And I also read it, any bills that were passed through some of the sitting senators where monies were supposed to come into the system, that we would no longer receive that money. And then any other opportunities through the matching fund monies coming through the Senate, that we would be blocked from getting that money as well. That's how I read that particular section.
Mr.
So
Dorsey, employee contributions, I don't believe are in the budget. That comes directly from the employees' salaries. So I don't think that would be included. That's money they take from the employee's paycheck and turn it over. And so it would only be those monies that are in the 2022 budget to be turned over to GRS, which would be the employer contributions, any of those other bills that provide yearly money to the GRS, only for 2022 would it not be paid to the GRS. That's my understanding of the bill.
Do you see the bill has, as Trustee Russell indicated, it just has a lot of bells and whistles for a short period of time that we're reviewing this. I think that provision, it definitely needs to be cleared up, but it just needs to open it back up to how it is currently. Any opportunity for us to get funding needs to be available to us. I've said this in many meetings. We need to start to do or attempt to do what the executive director has been doing successfully at the Port Authority when it comes to going to the Senate and asking for monies to help build up his system. And we haven't scratched the surface on that. And we have sitting assets to do that. So I don't want this provision to block us and going to the Senate and requesting funding, because at some point it will happen. It may not happen with this particular set of trustees, but it's going to happen. It's just a matter of when. So if this provision blocks those type of opportunities, then that needs to be fixed as well. So I'm saying that to you and Mr. Niz when you're doing your proposal on that particular section. We need to be able to have those opportunities.
Okay, Mr.
So,
Dorsey, again, this only applies to fiscal year 2022. So
But
it's a
something might
limited
happen in
amount of time.
22, Council.
No, I'm
Something
just
might
saying it's
actually
not
happen.
forever. That's all I want to make clear. It's not forever. It's only for fiscal year 2022.
So then at this point, we could just take that out or make the request to remove that section. Then that's not even necessary at this point. Even if it's for the 1 year, it's not necessary because the system right now, as we all know, sitting here, we need every dime, every penny we can get. I wanted to have one other question. In the questions section of your document, are you going to go through that?
No, Mr. Dorsey, because that's not questions pending to this legislation. Those are just questions that we need to have a further discussion on, that we need some clarification from the governor's team. And I don't even know if they possibly have those answers, but once the documents are created, after this bill is approved by the legislature, then we need to get into those other questions that would, from the financial team. So
Yeah, but
those were not questions for the legislature.
So that would be, wouldn't that be too late? Don't you want to get things suggested before for the meeting you have coming up so that can be part of the bill?
No, this is not to be part of the bill, and it's not in the bill. This is stuff that goes in the actual financial documents that we need to see. So it's totally separate. It's just something that we wanted the board to be aware that we need to look at in the future.
So do we get an opportunity to participate in that document, putting that document together? Do we get that opportunity as well? Because you have some very good questions here. I think number 5, who would control the GRS bond? The GRS board or the GRS or the trustees? I mean, those are good points.
That's up to the chairman how he wants to handle that, Mr. Dorsey.
Well, that's not with the financial team.
No, with the financial team. I'm saying I don't know how he chooses to deal with that. That's up to the chairman.
The chairman of the financial team?
Of the GRS board.
GRS.
Okay, so these are just questions for us as board. That's what you're saying?
Yes, for us to investigate, discuss, look at, maybe ask the governor's financial team to clarify some issues, but this is not related to the legislation.
Okay.
I read,
So,
I don't understand why the legislature would prevent the GRS from even receiving an appropriation in 2022. It don't make no sense to me. Why that language, that whole language should be removed? Because any money we could get in any year beginning now would help us.
but let's be realistic about what we're talking about. We're talking about a piece of legislation to be considered. Mr. Attorney Russell knows that the legislature of the Virgin has full and total discretion about how public funds, whether he like it or not. The fact that you don't understand why they should want to do that, I mean, that's within the prerogative. What we need to do is focus on what is before us and how it impacts GRs. And I mean, if Kathy is, if the direction is that Kathy include that as a request for an amendment, then that's fine. But I mean, the question about why they want to do that, I'm not sure why they want to do that. I mean, but as trustees, we don't have any say about why they want to do it. Okay? How to spend money. I mean, that appropriations are totally within the jurisdiction of the legislature. So we've been in this now about close to an hour and a half. I need to bring this thing to closure. And again, as I'm saying that the way I have summed up this discussion is that the board is substantially in favor of the plan, as subject to some concerns that we have, which the attorney will submit. Mr. Nibbs in his testimony will submit for recommendation for amendments. I'm not sure, and Attorney Wesley probably have better insights than me on this one. I mean, my understanding is that the body meets as a committee of the whole, and then that will adjourn, and it will go right into a full body hearing, full legislative session. That's my understanding. And the invitation says, I don't remember the exact words, but the indication suggests that's what's going to happen. So I'm not sure what opportunity will be available for any serious amendments between committee of the whole and the body. So we'll see. But am I summarizing the board's position correctly, that we are in substantial agreement, or we substantially support the effort and the legislation and the financing that it embodies?
Chairman Bory, so when we say we support the bill at this point, because we have a bill that has, I guess, the original bill, I guess, from Government House, and then we have the markup from the Senate. So in this case, we're supporting this bill with provisions based on the position of this bill's sponsor and the Senate at this point. Is that how we're going forward with this? Because we got two different people that we're back and forth with these sections.
There's only one measure before the committee of the whole. That's the one that's the most recent one. Apparently, the one that was marked up. That's the
Okay.
one. That's the only bill before the body.
Okay. But I'm just trying to figure out, how do we state the white paper? How do we present our position? Who are we presenting this to at this point? Because we have two different parties here. Are we presenting it to the two parties to let them know where we stand? Are we doing two separate letters?
Who parties you talking about?
The bill itself, right? This originated from the governor, his team, and the markup of the bill came from the Senate. This is what they're going to discuss?
That's
on
what,
on Monday?
that's what they're gonna discuss, the one that's marked up by the subcommittee.
So the question I have, when we say we are in support, we're in support of this bill. So we're just saying the bill, and we're just speaking to the bill number itself at this point.
Yeah. And that's before the body.
Okay. I'm just trying to be clear. And I had another question, Chair. Those questions at the end of the section for Attorney Smith. Does this the payments, if the payments are not able to be made to the bondholders, right? And they would then the liens that would be put on, nothing's going to be leaned onto the system. It's just the liens will just be leaned onto the special purpose vehicle itself. The obligations to pay the bonds is only connected to the special purpose vehicle, nothing is tied to the system itself, right?
That's correct, from my understanding. The GRS is just like the rum companies. We're gonna hold that bond and they owe us to pay us on it.
Okay.
There's no obligation for the GRS to pay anything to these.
Okay.
Let me suggest something here. Mr. Nibs, you would have any problem with having Attorney Smith accompany you and her making the presentation about our concerns and being able to say to the senators, in this language, we suggest a change like this, because we need somebody there. It's not a free for all. We have an interest to protect.
Senator, you're assuming that I don't know, what Kathy's talking about. I am going to deliver the testimony. I always take legal counsel with me. And if I'm not too sure of certain things, she would respond.
Okay, good. I want that because I think as a legal counsel for the system that did an analysis, it would be good to have her deal with you because she raised some serious concerns. And there are loopholes that we have to at least ask them to address. I don't know if they're going to address it, but there's serious loopholes. Thank you.
Okay, and I just want to clarify, it was not me alone. I also had the assistance of Attorney Myers and Mr. Henderson, who also especially took a lead in the financial portion. So I don't want to take any credit for it. It was a team effort, and also with Mr. Nibs. He looked at everything and reviewed and gave us his input. We work as
Well, carry the team. Carry the team. The senators have the team there, and if you need to call on them, because this is significant legislation that can't be. They are going into a special session to approve it. That's how it goes. So, and the testimony is significant. They will make the changes right there before the special session, recess, and do it. So carry your team, Mr. Nims. You have a good team. Thank you.
Attorney Smith, so just for my last point of clarification. So you're saying the GRS in this process of this special purpose vehicle, we would be sitting, I guess, in a third position of monies that will be coming off the top, meaning that the two rum companies will get paid and then we will get paid third?
Debt service for the two rum companies come, and then after that money is paid, GRS gets up to 158 million on what's left over. So technically GRS is in third place because the two rum cover over bonds have to be paid. The debt service on that is paid before GRS gets paid.
Okay, but my clarification, it actually says that someplace in there, right? There, page.
Yes, it does say, and Mr. Bowery is probably better at this than I am, but yes, the debt service on those two bonds are rum cover over bonds are paid, and then GRS gets the remaining up to 158 million annually.
Miss Attorney Smith, I think Trustee Russell hit on it earlier, but is there any reason why this is capped at 158, are you saying there'll be years that there'll be more than 158 they could technically pay us, pay the system?
Yeah.
So why that money couldn't just roll over into the GRS account instead of us looking at from the standpoint of less money coming in a particular year, we could at least be in a position of strength and draw down. And maybe the following year, I guess if it comes to that, we can give back a portion and then we can still hold a portion so that we could always start out with a deposit amount of money on hand cash that we would be able to draw down from during those years when the system or this process might be coming up short. I think that's a different way to look at this language that should be proposed to the Senate.
Mr. Dorsey, I'm not in a position to opine on that. I don't know the reasons why it was done the way it was. I only look at the legislation for protecting the GRS. So I can't.
No, I'm asking Attorney Smith, that is something we need to recommend, because now that you just said that cap at 150, if there's additional money, what is the reason why they wouldn't want to pay additional money into our account? Why not just put it there? There's some kind of vehicle or system or process we could put in place so we don't have to, at least it'd be like a backup plan, because we don't have a backup plan, right? But within those months or years that we have monies short, we would have it on hand, so we wouldn't actually have to touch our investments. It's just a different strategy that we can present. We can just present it. A senator might say, hey, that makes sense.
Mr. Dorsey, that's not up to me. That's a board decision.
Or maybe what can happen is,
I mean, the government has other responsibilities in addition to GRS. There's other things that get paid, the other funds, money things that get paid out of that matching fund. The government is funding the system sustainably. That's their responsibility. I mean, the other responsibilities the government have.
Yeah, but let me chime in here, Mr. Bowery, and I could understand that you promoting an idea. We don't have to agree with that idea. Because
I'm just answering the question.
Yeah, because the other responsibilities, the GRS has been neglected for so much. When Gruff came up with the same plan, the governor rejected. So I believe there should be a cap, 158. And any residual after 158 should go to the GRS to reinvest the investments that they had to draw down when the government wasn't providing the money. Okay, that's a suggestion. Thank you.
Mr. Nives, you had something to say?
no, I said another option would be to raise the government contributions, the rate. I mean, I know that Senator Valley had some legislation. He did send it to us to raise it to 33.5. Over the years, if they come into that situation, maybe we can recommend a rate increase. I don't know. That can fill the gap. There's all kinds of things, but like Trustee Barry says, you have other obligations. You got to look at the general fund to see, to determine if there's any way it can be done.
Well, I would just say this. I'm not sure what those other obligations are. I mean, how this was presented, it was presented that the run cover over companies have to be covered first. They'd be 1 and 2, and then we would be 3. And then the servicing of the bonds is another cost. This special purpose vehicle, it doesn't have any employees, so technically it doesn't have any overhead. So I'm saying to myself, this is like a cash cow situation, and our system is in need of cash. So even at 158, I understand it's a big number, I understand that's only going to meet our yearly obligations at our current level. But I think, if there's extra money, I really think we need to put that in, because that argument that Trustee Russell just made, that really brings it home, because these years that we haven't been, the plan sponsor hasn't been meeting their obligations. I mean, how do you go back and recoup that money? This is one of the ways you could actually do it. And we could put a sunset on this approach. I'm just saying it should be suggested to the Senate to put it in. It should be suggested to the Senate to put it in. And I guess the chair of the Finance Committee, Senator Ville, he might even say it makes sense. He's the chair of the Finance Committee. It might ring a bell. So I don't think we should be capped. I think all that difference needs to come in. I think the general fund, from where we sit and based on the territorial address, if I heard the governor correctly, the system is full of money right about now. We probably got more money coming in than we got people to fill the jobs for the positions and opportunities we have locally, just on the capital funds, the federal funds alone. So I'm not sure what obligations. No one has shared that with us. We've only gotten this part of the picture. So I'm only speaking on what we have in front of us.
What we have in front of us is $158 million. That's what we have in front of us.
Yes, that's correct, Chair. We have 158 million with recommendations in front of us. That's what we have in front of us with recommendations.
We need to bring this meeting to a close. We have another item on the agenda. And again, my understanding of what, and I don't know how we want to articulate this. I don't know if we still have a quorum or anything. I'm not sure. But the purpose of the discussion was to determine, I guess, what the board's position.
Yeah. Okay.
On the item that's in front of us.
Okay, Mr. Murray. Is Mr. Calwood still on line?
Yes.
Okay, well, let's take a vote. And I gonna vote for it. But I gonna put the caveat here. And I gonna make a motion that the board supports the measure that was sent down to us by the legislature, with commentary from our executive director as to our discussions and our requests for modification.
Is that your motion? Second.
Trustee Calwood.
Abstain.
Go ahead.
Oh, I'm sorry. Trustee Calwood.
Not voting.
Abstain. Huh?
Abstain, not voting.
Abstain. Trustee Dorsey.
Yes.
Trustee Liger, absent. Trustee McDonald, absent. Trustee Russell.
Yes.
Trustee Smith, absent. Chairman Barry.
I need to get specifics about what those items are. So as I understand the motion is that the board support the legislation that's before the committee, and so is that saying?
So
Is that saying that the support is conditional upon the acceptance?
No. We supporting it, but we want them to entertain our requests. That's all.
Okay.
They don't have to.
Okay, I
But
understand.
we want to be able to put a full picture of what Kathy just said and some of the things, because we need clarity about
Okay,
whether
okay.
they're gonna pay it in. Yeah. Okay. So it just, we making requests with all requests, and then they're gonna do what they want.
Okay.
Chairman Barry,
I'll vote yes on that. I mean, that's what's gonna happen anyway.
Thank you.
as 3 yes, 3 absent, 1 abstain.
And all it is, Mr. Bowie, is that it's a more forceful presentation.
Okay, I
where,
got you.
yeah, we review it and we got some requests and that's it. We
Um,
like it, but we want the requests to be considered, and they're gonna do what they want anyhow.
Okay. So, so you're clear, Mr. Nibbs, on what the testimony?
Yeah, I'm still a little concerned about the one with the refunding that had the $4 million. I don't
No,
know.
with that I've taken out.
You're gonna-
Mr.
you're gonna
Nixon.
take
I'm
that out?
revising it. Yeah, I'm revising it for you.
Either or take it out because.
Yeah, I've taken that out.
Yeah.
But I'm revising the other suggestions, so.
Except,
Yeah,
yeah.
Kat, Attorney Smith, don't water it down, you know. We need
No,
you.
I'm not watering it down, but
Oh.
based on what Mr. Bowery said, that's a non-issue. And so we don't want to put stuff in there that's a non-issue. We want to focus on the things that are important.
Okay, good. Okay, I good.
All right, so,
Carlwood is still there? Carlwood, you don't,
Carlwood, yes, he's there.
you disagree with some of those things that Attorney Smith was saying, Mr. Carlwood? Just straight up.
We voted, it passed. Let's move on to the next item. Very good.
Okay.
so the next one is, what's the other one? Bill number,
The return to work bill,
yeah,
4.0171.
yes.
I think, could you pull that one up? I know that we got some amendments that were submitted earlier today from Senator Potter's office. Those were circulated. Kathy, I'm not sure if you had a chance to look at those. I circulated them to the trustees. However, we really didn't have, we just had a few issues that we would like to be considered.
So, I mean, just to summarize that you're basically in favor of legislation subject to a certain,
Yes, yes.
okay,
And they gave you a format that you respond to, whether you are for or against, advantages and disadvantages. And the economic impact, I said, based on the average actuarial salary in the actuarial valuation report, about 46. If you have 1,000 vacancies at using the tier 2 regular rate of 11.5 and the 23.5, it would come to about $18 million additional. So any additional contributions to us is great. And we did some recommendation.
just let me jump in, just to clear in my mind. This is not on the agenda. Is this on the agenda for Monday?
No, it's for Tuesday.
Okay, okay, go ahead.
And I'm not sure, Katya, I didn't have a chance to look at the amendments that came in. I'm not sure if the break-in service, I saw something about 36 months. Just a cursory look, but what we were saying is that the return to work policy of various pension systems determined what was the break-in service requirement. The break-in service requirement ranged from 30 days to 12 months, meaning that someone can return to work in 30 days or 12 months. For the proposed legislation, I'd recommend an 18-month break in service. And then we talked about Internal Revenue Service. Internal Revenue Service has a provision about employees returning to work. You know, they have to stop working. And their break in service recommend is like 90 days break in service period. So we were recommending that to be in accordance with the IRS, we recommend that the sponsor of the bill consider amending the proposed legislation to include a break in service of 90 days to 12 months. So you can't come back before 90 days. And so that's basically it. But they did submit amendments. Kathy, you like to read amendments? Attorney Smith. Now let me see.
Mr. Nibbs, I'm sorry, I was on mute. I'm
Yeah,
looking,
sorry.
let me stop
Yeah.
sharing this document. I don't believe if it came in this morning, once the
Yeah,
meeting started, I haven't seen them, but let me look for them.
I sent it to you this morning. I got it in from the senator's office.
Okay,
And
let me.
I circulated it. Let's see.
Okay.
No, I don't have them, Mr. Nibbs.
I sent
Oh,
it
here's
to you this
amendments. Yes, I
morning.
do.
Yeah.
Oh, it says see email below. Okay. Let me see if I can,
It's talked about the age, the participation of the age. You can't be over a certain amount of age.
let me see if I can pull up this email. I'll try and see if I can share the email.
I don't see what you're talking about, Mr. Nibbs.
The break-ins, excuse me?
I don't see the document you're referring to. You said you sent.
I thought I did send it to everyone.
No, I didn't get it.
Okay, let me try to
Hey.
get this another way.
Hey,
Okay.
Kathy, could you send it to me?
I'll
I
send it to everybody.
haven't seen it.
Okay, I will. I thought I did. Okay.
Okay, all right, let me try to get this up another way, so see if we can share the screen. No, I think I have too many things open, so let me see if I could close out some of the things that are open. Okay, let me see if I can share it now. Okay, here we go. Okay, can everyone see the screen?
Yes, Attorney Smith.
Yeah, I see it.
Yes.
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 Sorry, I just, okay.
Mr. Nibbs, these are amendments that the senator will put forth on Tuesday to change his bill. That's what I suggest, right?
That's correct.
Okay. Mm.
How are we going to move forward on this, Mr. Nibbs?
No, I would just look at I don't think there's too much conflict, and I think we requested that they change the break in service period. I think what they're doing is adding additional meat to the legislation. I saw it as an age participant, the age, there's an age cutoff, I think.
Well, it says that people under the age of 65 must switch to the active government insurance program.
Right. So
Okay.
that was discussed in the stakeholders meeting. So we don't have any problem with that. The only issue we had was the
Mhm.
break in service period, obviously.
They're adding an annual, the participants will earn annual and sick leave. That doesn't affect the GRS.
No.
And no lump sum payments. But okay, so I don't really see anything that affects the GRS.
Correct.
So,
Okay,
so going back to the original document, is there anything that we have an issue with?
No.
Okay. So.
let me make a suggestion here that I was thinking about if we had the meeting in a policy. I believe that there should be either a penalty, you call it a penalty. If you call it that, it'd be, not attractive, but coming back into the government service and you essentially being allowed to double dip, I think they should pay a higher percentage to the GRS for the GRS allowing them to double dip. If we're going to allow them to double dip and the 11% maybe need to go to 15%, 18%, pay to the GRS because we allowing them to double it.
Yeah, but we're not losing anything.
We're not losing anything.
No, but you're
losing
losing.
anything.
No, I understand that. But as a system, it was a very sound policy not allowing people to go in. We accommodating the executive branch and we ain't losing nothing. We should gain some more.
They're paying in a tier 2 rate, which is the official authorized rate, which is higher than the rate that they paid into when they were there.
Right. If the tier 1, okay. And so you don't think they should pay an increased contribution to the GRS?
No.
We're not losing anything because if this program was not in place, we would have been getting the same thing from the active employees, the new people coming in.
Right.
But at a lower salary, Mr. Nibbs.
At a lower
New
salary
people-
also.
yeah.
New hires would have probably came in at a lower salary and we were getting the same rate, but
And
less
also,
contributions.
we pay some of the highest rates among pension systems as it is. And if you ask somebody to pay 15% and they get no additional benefits, I think that's a little stretching it a little.
Our concern is the additional contributions. That's all we're concerned.
And we're getting that.
Correct.
So that, okay. So that the problem I see is that, hold on, is that we allowing double dipping and all we getting for it is a contribution if they went stateside and recruit somebody. But we allowing now them to tax our government because it's one government to double dip without some kind.
How the double?
Well, look. If the government was able to recruit people off island and they had to pay into the system, they pay one thing. Okay?
They're pretty same.
Yeah. Well. No, they ain't have to recruit. People here who now qualify could receive the annuity and the salary the government can get them.
Well, what we're saying, Senator Russell, the governor went out in the states trying to recruit. I don't know how much. I asked the director of personnel yesterday to give me some statistics, but I haven't received anything. But they went out and recruit. Most of those individuals, the young folks, do not want to come back to the Virgin Islands now. And I've speak to a lot of them. They don't want to come back now.
I mean, the proof of the pudding is all those vacancy positions that
Right.
show up every year after
Oh.
year.
Right. Also,
Yeah,
it
but
should be noted, there are some positions that do allow comeback. We have teachers that come back, we have nurses, we
Police
have
officers,
police officers, and they're not paying anything right now.
nurses, they're back right now
Okay.
and they're not paying any contributions. So this would, they would
Okay,
have to
then
start
you
paying contributions.
want to correct that, yes. You want to correct that, and I understand that. And my view is, if you allowing, it's one pool, gross receipt, property tax pay one thing. Why we shouldn't collect a little extra if you want to come back getting an annuity from us? That's all I say. And if we don't have a consensus, I'll back off because, you know, but I think we should.
I
If we don't have a
judge that.
consensus, I'll back off. But my view is, you're coming in, you're getting a check,
Mhm.
and you're coming in, and you're only paying what somebody from any place would pay. No, because you taxing our general fund. So you got to pay a little more into that if you want
Well,
to
the
come back.
general fund would have been taxed anyway for a person that came back. I mean, a new hire was there.
Okay. I ain't gonna support. Okay, but I gonna support it because it closes the loophole of coming back and not paying nothing. But I believe somebody who live in Bovoni and they retire, they get a good check, and they tap to come back in, should pay a little more.
But
Anyhow,
you must remember, Attorney Russell, they have to go through the procurement, the personnel process, you know, they have to be qualified. They have the positions have to be advertised and it's competitive. They're not just pick them up and just come back.
No, but it got a lot of people qualified here, Mr. Nibs.
You need to tell,
The people here, listen,
tell the
the
governor where they are.
retirees here well qualified.
You need to tell the governor where they are.
They're not applying for the positions.
Year after year, the vacancies show up in the budget.
Yeah, the vacancies, because they're firing people who didn't show the fire, all the politics getting in the way of merit service. The politics is ridiculous. People could, you know, and that's what blocking it. And you know, I ain't gonna get into politics right now, but the truth is, we could tell them in the legislation, pay a little 15% and you come back. That's my view. I know it's not a consensus, but I don't believe this government should be paying double like that simply because the administration is don't advertise and do the proper thing to get people to work. You know, people want a job. If they, you know, so I leave it there. I leave it there because they look like the corrections and the amendments are good. From what I just see cursory. So, you know, I good.
Okay.
I have a question. Chair, I have a question. The unused annual leave and sick leave that you accumulate, they're saying that, or this amendment is saying that you wouldn't be entitled to that. What exactly are they saying here? Because everybody else is entitled to annual leave when they leave. And when they say you're not entitled to sick leave, they won't have sick leave if they come back to work? Or is it upon separation? Sorry. So you normally don't go with your sick upon separation, but you go with your annual leave. So I'm trying to figure out what's going on with that. That's gonna be changed? That's gonna be different for new people coming in?
That's technically that's not a GRS issue.
Right.
But I thought the GRS, the money's paid to the system from the agency the person's working from. The check is not cut from The combination of the agency and the GRS? I thought that's how that worked. That ain't how that worked?
Yeah,
The current retirees checks?
Yeah. No,
Yeah.
the annual leave you accumulate when you're leaving, that check is cut from the GRS once everything is.
Cut from GRS, cut from the agency, finance or somebody.
Oh. Okay, I thought it came from you.
Our main concern is the additional contributions. Let's not miss the ball.
No, that's not what I'm asking, Mr. Nibbs. I understand that point, but I thought
No.
the annual leave.
No, Mr. Dorsey, when you leave an agency, like when I left WAPA, I got a check for my annual leave that I had accumulated. My
Right.
sick leave would be transferred if I went to another government agency. They would transfer that sick leave to the new government agency, but you do not get a payment for your sick leave.
Okay, so what happens in this case with the annual leave? That's what I'm asking. What is this
Okay.
bill saying? These individuals
it
will
says
not
won't be
get
paid out.
annual leave? They won't get
Yes, you
paid
won't
annual
be
leave?
paid out annual leave.
Yeah, but they would be discriminating against the current employees that are under the CBAs in those agencies. That's discrimination.
Not if you're
Dorsey, they
returning to
collect-
work, Mr. Dorsey, you're returning to work, you're collecting your annuity and a salary. I think asking to get a lump sum for your annual leave that you may accumulate is a little much in getting benefits.
No. You're missing. You guys are missing the point. When you come back in, you're coming into a collective bargaining agreement, which is happening now. There are tier 2 people and tier 1 people under the same collective bargaining agreement. These people are going to be coming in as tier 2. They'll be part of the collective bargaining agreement. So I'm just saying, how does that work? I mean, you would be discriminating against those individuals in that situation.
I think that would be up to the government to negotiate this
I'm
with
not sure.
the unions.
I'm not sure why it's called discrimination. I mean, clearly the government is creating a new category of employees.
Mhm.
I mean, this legislation speaks to a new category of employees. And when you come into that new category, you come in with the understanding that this is the deal.
Yeah, but you're still coming under the CBA. What are you trying to say? Maybe you're not aware of it, Chairman Bori. There was a federal law that passed under President Trump as related to CBAs and employees, private sector, public sector, as relates to the CBAs, right? So when that law passed, it talked about discrimination and coming into the workplace, which would supersede what's being proposed here.
But
I
Mr.
don't
Dorsey,
know who prepared this document, but that's
that's not an
discrimination.
issue for GRS, Mr. Dorsey. That will be between the government and the unions.
Yeah,
That's an issue for the union. Yeah, that's exactly what I was going to say. That's an issue for the government, the union, and the government to work out.
Yeah,
Exactly.
GRS has nothing to do with this.
Nothing to do with GRS.
Okay.
As a union rep, if you want to bring it up, you bring it up, but we have nothing to do with it.
Well, I couldn't bring anything up. I was never invited to anything, so I don't know. This is the first I'm seeing this amendment today, and
I think there's something in the legislation. I think that there's going to be some discussion. The employees have to be hired but have to go through the personnel director. And I read something that there's going to be some discussion with the union and that between the government and the union. It has nothing to do with us.
I hear you. Okay.
Mr. Chairman, both the union and personnel was at that meeting, the stakeholders meeting. They raised questions. So, it's up to them to make that known to the senator. I don't think we need to get involved with that.
Mr. Niz, when you said both the union was there, you're referring to a person?
Mr. Jackson was there.
He doesn't. He only represents his shop. There's 36 bargaining units, Mr. Niz.
So you think it would make sense to have 36 unions at the table? Trustee Dorsey, that's what you're implying?
I'm implying that whoever put this together should have thought it out a little better. That's all I was saying. If this came from Mr. Potter's office, his staff should have thought this whole process out a little better. That's what I'm saying. And yes,
And
and
your
to
statement,
answer your question,
and your
answer your
statement is based on
question,
your legal
to
education
answer
and
your
legal expertise.
question, trustee,
Okay, all right, so then,
right? To answer your question, if you're gonna do something with bargaining units and you know there's 36 bargaining units, the proper thing would have been to do for Mr. Potter is invite all 36. You don't invite one bargaining unit because all our units operate under different paradigms.
Mr. Dorsey wasn't invited to the first one. You won't be invited to the second meeting. And that's just the way it is.
Say that again?
that's not an issue for this.
I didn't hear what the trustee said. What do you say, Coward? You can repeat it, Coward?
Mr. Dorsey, as you know, as a trustee, when you sit in as a GRS board trustee, you have to take off. You can't wear two hats.
I'm not wearing two hats, but
You have to wear one hat.
Coward made a comment as though
Just saying, you have to wear one hat.
Mr. Nibs, Coward made a comment as though he may have some insight on this. That's all I was asking. He said one group
No,
was
I don't have any insight on anything.
really, Coward, but you just made a comment.
I asked a common sense question. I asked a question based on common sense, not a thing else.
Well, it was common to you, but that's not common sense. It was common for the senator to invite all the bargaining units. If you're going to be fair across the board. That's all I was saying. But I was saying whoever prepared this document didn't use any common sense.
All right, so let's move on. So from a GRS perspective, we're going to make those suggestions. Where are we on this? With respect to this meeting, what do you want from the board here?
I would agree with Trustee Russell that if people are coming into the system, they need to pay more money. And I think the 15% that he recommended is a very good point. And I'm not sure why that office for Mr. Potter and the people who put that document together didn't suggest that in the document.
But that is not an issue for GRS, right? It's not a GRS issue. So with respect to the GRS testimony, that's not an issue. So, Mr. Nibs and Kathy, are you clear?
Yeah, I mean, we support the bill, and the advantages would be additional contributions coming in to the tune of about plus or minus 18 million. Could be less, could be more. And we just want to make a recommendation about the break-in service and bring to the attention the IRS codes provision. And that's it, but we in total support of the bill.
Okay.
I'm in support of the bill with the recommendation by adding the recommendation by Trustee Russell of increasing those individuals to pay the additional 15% to the system. Then I would be in support of this bill.
Motion.
My motion is that we make the request that the bill include the additional 15% to be added to those new employees, since this is a new category for those new employees.
Additional 15% or 15%?
15%. It's 13% now. It's 13% now, Mr. Nibs.
11.5%.
Yeah, so 15%.
I mean, there's no rhyme or reason to this. But go ahead.
Second, third.
Is there a second? Dies for lack of a second. Okay.
Do we have all the trustees here? Hello?
You have 4 trustees and there's a quorum.
Can't hear the trustee. We lost him.
So you're talking about taking the vote over? That's what this is about?
Yeah, we lost the trustee. We didn't have a quorum.
Okay. So we have a quorum now?
I'm trying to ask
Wait a
the,
minute, listen, you could hear me?
yeah, we couldn't hear you before. I made a motion on increasing the percentage from the 11% to 15% for the new category of employees. You still there, Russell? Hello? You gone again?
All right.
He's on the line. I don't know what's the problem, but he's there. Mic is open and saying that his video is open. Maybe he can call in if he's hearing us.
Hello?
So we don't have a quorum.
Well, he's there. There he is.
Okay.
But I'm sure he's having some audio or something.
So we don't have a quorum.
We have a quorum. Let me see. Someone has. Miss Glendinning?
Yeah, and I would second that. I just get.
Okay, seconded. Okay, you said you seconded. Mr. Chairman? He said he seconded.
That's a roll call.
Yes. Trustee Carwood?
No.
No. Trustee Dorsey?
Yes.
Trustee Liger, absent. Trustee McDonald, absent. Trustee Russell?
Said he can't get in. He sent me a text, say he can't get in, so we don't have a quorum.
Okay.
He can call in on his cell phone.
It look like he's back.
No. He's back. He's down in the bottom. Mr. Russell? So he has some problems.
You could hear me now?
Yes, what is your vote,
Hello?
sir? Yes,
You could hear me?
yes. What is your vote?
Yeah. I vote yes and with a 15%.
Trustee Russell, yes. Trustee Smith,
Yeah.
absent. Chairman Barry,
No.
2 yes. 2 no. I'm sorry. Yes, 2 yes, 2 no. And 3 absent.
Okay.
3 yes, 2 no, 3 absent.
So the motion dies. Okay. So could I get a motion for adjournment?
Okay, so Mr. Chairman, do we have any guidance for our testimony before the legislature on Tuesday?
Which one?
For the Senator Potter's bill?
We just indicated to them that we approved it. We in favor of the bill. We have no opposition. So now the advantage is additional contribution to the fund.
Okay,
And we gave them an estimate of collection plus or minus.
Okay.
okay,
We indicated a recommendation about the time, the
the
period.
break-in service, yes.
Break-in service.
Okay, that's fine. As long as we're clear.
Could I get a motion for adjournment, please?
Mr. Chair, I move that we adjourn this special meeting of the Board of Trustees. I so move.
Can I get a second?
Yeah, second.
Roll call?
Trustee Carwood,
Yes.
trustee Dorsey,
Yes.
trustee Liger absent, trustee McDonald absent, trustee Russell,
Yeah.
trustee Smith absent, Chairman Barry,
Yes.
4 yes, 3 absent.
Thank you all very much. Thank staff, thank board members.
Yes.
Enjoy your weekend.
Okay, thank you.
Thank you.
Have a good
Thank
weekend,
you.
everyone.
Kathy, call me, okay?
Yeah, I'm gonna call you right now.